Hello, check. Hello, 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 check.
Check, check, 1, 2, 3. Hello, check,
Hello.
hello, check, hello, hello, check.
Good evening, everyone. I request honorable dignitaries to kindly grace the dais. I request Honorable Sri Justice Vibhu Bakru, the Chief Justice, High Court of Karnataka and Patron-in-Chief, Karnataka Judicial Academy, Honorable Srimati K.S. Mudgal, Judge, High Court of Karnataka and President, Karnataka Judicial Academy, Srimati Ranveer Kaur, Chairperson, Competition Commission of India, New Delhi. I request our Director, Karnataka Judicial Academy, Srimati H.R. Radha, to kindly escort the dignitaries to the dais. A very good evening to one and all. It is indeed a matter of great honor and privilege to welcome this august gathering to the Competition Advocacy Program on the brief introduction of competition law and judicial trends. This program has been convened to deliberate upon one of the most significant and evolving areas of contemporary legal discourse, competition law, and to reflect upon the judicial trends that continue to shape its interpretation and enforcement within our legal framework. On behalf of the organizers, I extend a warm and respectful welcome to each one of you present here this evening. We look forward to an enlightening and thought-provoking exchange of ideas that will contribute to a deeper understanding of competition jurisprudence and its growing relevance in today's economic and legal landscape. With these words, may I seek the permission of His Lordship to commence the proceedings with state anthem. Thank you, my Lord. I request everyone to kindly raise for the state anthem. Thank you all. To ceremonially begin today's proceedings, I request Srimati H.R. Radha, Director, Karnataka Judicial Academy, to deliver the welcome address.
A very good evening to Honorable Sri Justice Vibhu Bakru, Chief Justice, High Court of Karnataka and Patron-in-Chief of Karnataka Judicial Academy, Honorable Srimati Justice K.S. Mudgal, Judge High Court of Karnataka and President of Karnataka Judicial Academy, respected Srimati Ravneet Kaur, Chairperson, Competition Commission of India, Honorable Governors of Karnataka Judicial Academy and other Honorable Judges of the High Court of Karnataka, Additional Solicitor General of India Shri Arvind Kamath and Deputy Solicitor General Shri Shanti Bhushan, Office Bearers of Advocates Association Bengaluru, learned senior advocates and young members of the bar, Registrar General and other registrars of the High Court of Karnataka, Srimati Bhavani, Principal Law Secretary, Shri Reddy, Principal City Civil Court Judge, Director, Secretary and Deputy Director of Competition Commission of India, Srimati Jyoti Bhanat, Senior Economist from CCI, distinguished invitees and ladies and gentlemen. I feel privileged to welcome you to this competition advocacy program organized by the Competition Commission of India in association with the Honorable High Court of Karnataka and Karnataka Judicial Academy. Karnataka Judicial Academy aims to achieve greater heights in knowledge sharing and judicial education under the guidance and leadership of Honorable Shri Justice Vibhu Bakru, Chief Justice High Court of Karnataka and Patron-in-Chief of Karnataka Judicial Academy. My Lord, we are deeply honored to have you with us, and your Lordship's presence means more than a ceremonial participation. On behalf of everyone present, on my own behalf, I extend a warm and hearty welcome to my Lord the Chief Justice. Welcome, my Lord. We are equally privileged by the presence of Honorable Srimati Justice K.S. Mudgal, Judge High Court of Karnataka and President of Karnataka Judicial Academy. We are grateful to her ladyship for all the support and extend a cordial welcome on behalf of the organizers. A very hearty welcome to respected Chairperson of Competition Commission of India, Srimati Ravneet Kaur, who is here to share valuable insights on the competition policy and the laws to sustain market fairness and consumer welfare. Ma'am, we are eagerly looking forward to your expert perspectives on the subject. Welcome you, ma'am. Honorable Judges of the High Court of Karnataka sitting at Bengaluru, including the Honorable Governors of Karnataka Judicial Academy, have graced the occasion with their august presence in person. Honorable Judges sitting at Dharwad and Kalburgi benches of the High Court are present virtually. We are grateful for their gracious presence, and I, on behalf of the organizers, wholeheartedly welcome each one of them. Welcome, my lords. Evincing keen interest in the competition advocacy program, learned Additional Solicitor General of India and Deputy Solicitor General of India, the Office Bearers of Advocates Association Bengaluru, learned senior advocates and young members of the bar are present on the occasion, accepting our invitation. This speaks immensely of a close collaboration between the bar and the bench on such matters. I extend a warm and cordial welcome to each one of them to this program. I wholeheartedly welcome Shri Sukesh Mishra, Director, Competition Commission of India, Shri IPS Bindra, the Secretary of Competition Commission of India, Shri Arpan Mishra, Deputy Director of Competition Commission of India, Srimati Jyoti Bhanat, Senior Economist from Competition Commission of India, Shri K.S. Bharat Kumar, Registrar General and other registrars of the High Court, Srimati N.V. Bhavani, Principal Law Secretary, Shri Chandrasekhar Reddy, Principal City Civil Court Judge, Shri Dinesh Hegde, Director of Arbitration Center and his team of officers and faculty of KJA to this program. A warm welcome to all those watching the program live on KJA's official YouTube channel. I am confident that this program will enhance our understanding of the competition law and its growing significance. Once again, I welcome all in attendance. Thank you.
Thank you, Madam, for your gracious words of welcome. I take this opportunity to welcome our Dynamic Director for her leadership in convening this program. Welcome you, Madam. May I now request Shri K.S. Bharat Kumar, Registrar General, High Court of Karnataka, to present a sapling to Honorable Shri Justice Vibhu Bakru, the Chief Justice, High Court of Karnataka and Patron-in-Chief, Karnataka Judicial Academy, as a token of our reverence. Thank you, my Lord. May I now request Srimati Saraswati Vishnu Kaud Sundar, Registrar Judicial High Court of Karnataka, to present a sapling to Honorable Srimati Justice K.S. Mudugal, Judge High Court of Karnataka and President Karnataka Judicial Academy, as a mark of our admiration. Thank you, Your Ladyship. May I now request Srimati S. Nagashri, Registrar Infrastructure and Maintenance, High Court of Karnataka, to present a sapling to Srimati Ravneet Kaur, Chairperson, Competition Commission of India, New Delhi, as a gesture of our profound appreciation. Thank you, Madam. Now, I would like to request Srimati Ravneet Kaur, Chairperson, Competition Commission of India, to convey the opening address. Please.
Honorable Chief Justice of the Karnataka High Court, Honorable Justice K.S. Mudgal, President, Karnataka Judicial Academy, Honorable Judges of the Karnataka High Court, distinguished members of the Bar, distinguished members of the Judicial Academy, Registrar General and Registrars of the High Court, senior officers from the government, officers from the judiciary and from the Competition Commission of India, ladies and gentlemen, it is indeed a great privilege for me today to be present here before this esteemed gathering of the Honorable Karnataka High Court. It's an institution which is recognized for its intellectual rigor, unwavering dedication to justice, and significant contributions in shaping constitutional and economic jurisprudence. The Competition Act of 2002 was enacted to prevent practices having adverse effect on competition, to promote and sustain competition in the markets, to protect the interests of consumers, and to ensure freedom of trade carried on by other participants in markets. So the Act basically prohibits any anti-competitive agreements, it prohibits abuse of dominance, and it also provides for regulation of combinations, which are basically mergers, acquisitions, amalgamations. Besides this, under the Competition Act, we are also required as a commission to undertake advocacy, where we have to spread awareness about the Competition Act, and we would also promote compliance culture among all the stakeholders. In this journey that the Commission has so far undertaken, the Honorable Judiciary's contribution has been very fundamental, has been very crucial for us, because it has played a very key role in translating what was legislative intent into enforcement which is backed by actionable principles. The Honorable Supreme Court's decisions, we start at the beginning where in the year 2010, for the first time, the Honorable Supreme Court laid out the boundaries of jurisdiction of the Competition Commission, how we are to go about enforcing the Act, and what are the various principles that would need to be followed. Thereafter, we have had guidance from the Honorable Supreme Court, whether it was on the jurisdiction over SOEs, which is state-owned enterprises, because unlike other acts, this act applies both to the private sector and to the public sector equally. The issue which came up subsequently was this jurisdictional overlap with other sectoral regulators, where the Honorable Supreme Court in the case of Bharti Airtel made it very clear how the Competition Commission will work in case there is any such overlap in a matter. Of course, all along, there's been a lot of clarity which has been given to us with regard to the due process, the principles of natural justice which need to be followed, and the latest, of course, is this judgment in the shot glass matter, where the Honorable Supreme Court has talked about effect analysis before we come to any finding in case of abuse of dominance. Similarly, when it comes to the Honorable High Courts, especially the High Courts in the states where there is a good amount of economic activity, especially the Honorable Karnataka High Court, we have received a lot of guidance through various decisions of the court, and we have also seen that the Honorable High Court has enforced the centrality of procedural fairness when we undertake enforcement. Similarly, when we look at our appellate authority, which is the NCLAT, they have also made significant contribution to the evolution of this journey and have given us precedents. They have provided us how we go about ensuring consistency in our enforcement and providing clarity on complex issues. Therefore, all along, since the year 2009, when this commission came into force, when we started actually working, since then, we have found that the Honorable Judiciary has played a very crucial role in balancing economic freedom and regulatory oversight and ensuring that whatever work we are doing is dynamic and proportionate. And we are very grateful to the Honorable Courts for this guidance. Similarly, when it comes to the to the Commission, the Competition Commission of India, we have all along been very aware that we need to ensure principles of natural justice. And the observance of those principles has been given the highest emphasis by us in the Commission. When we conduct an inquiry, we give an opportunity to the parties to present their cases. There are opportunities given for cross-examination of witnesses, to respond to the findings of the Director General, and even after the investigation is done, when we come to the adjudication stage, we also give opportunity of hearing and of making submissions before any decision is taken by the Commission. And this is all laid out in our general regulations. Similarly, whenever we are looking at, because we have some things which are very unique to our organization, that is that we provide confidentiality to the parties to the proceedings. So whatever information we are getting is very commercially sensitive. And that can be information on prices, on business strategies, or it can be even their internal communications, their agreements with the upstream and downstream entities, and we are required to provide confidentiality on that. And therefore, this inherent tension between transparency and confidentiality is something that we are facing on a regular basis. And this is something which is also common to all antitrust organizations in the world. So how do we keep reconciling it? We try and arrive at that fine balance. Similarly, when it comes to the cross-examination, we have a regime which is called the leniency program, where we provide leniency to entities in case they give us information about cartels. Now, cartels in our competition law is considered to be the most egregious form of anti-competitive agreement. And there is no way that we can get the information unless some of the parties who are already participating in that cartel give us some information, because everything has to be evidence-based. So there we provide some concessions to the leniency applicants. We tell them that, fine, we will keep your identity, we'll protect it, we'll also keep your information confidential. And that's where sometimes there is a balance which needs to be struck between confidentiality and providing all the information to the contravening parties. So we are trying to resolve this through a confidentiality ring, which is what we have drawn inspiration from the Commercial Courts Act of 2015. And we are providing a confidentiality ring where we are allowing limited and supervised access, because a party against whom any finding is to be given must have access to whatever information is available on record against them. So we are reconciling that. So therefore, this process of enforcement that we are undertaking is very complex, and we don't want to discourage people from coming forward and giving us information about cartels. So we are balancing this constant endeavor is there, how to balance transparency with the confidentiality concerns of various parties. Similarly, when we look at competition law is interdisciplinary. It is not only a law, it is also based on some very fundamental principles of economics, where we are looking at concepts like market power, dominance, what is the relevant market, what are the foreclosure concerns, what are the theories of harm which is happening to competition in the market. Therefore, it's a blend of both law, public policy, and economics. And we do a very detailed economic analysis where we look at market concentration, we look at various parameters to define the same. Our Act also provides what are the factors you will consider before you determine a market and before you will determine dominance of any entity in that market. And on this, we have found that the orders of the Commission and the Honorable Courts have very important role to play because they shape consumer behavior, they shape the credibility of Indian markets, and also they encourage consumer confidence among people. Therefore, we found that the Honorable Court's decisions have lent clarity and predictability to the work that we are doing. I must also talk about some of the challenges briefly only, that one of the very important things is that markets are evolving very rapidly. And when it comes to digital markets, the rapid pace of evolution is sometimes leaving us also in a state where we need to very quickly adapt ourselves and be able to take action. Because the way markets operate, things can change very quickly. And once an enterprise reaches a tipping point, then in case we act, it's too late. It's not really worth it. The competition has already been eliminated from the market. With this thing in mind, we had a very detailed Competition Amendment Act of 2023, which was passed by the Honorable Parliament. And based on that, now, in the last 1.5 years, our people have been working day and night in the Commission, and we brought out all the regulations which are required to implement those provisions. One of the very important path-breaking things is settlement, which has been brought into the framework. Now, the settlement is something which is once the investigation report is done and there is a finding of contravention, at that stage, we allow the party to come forward and settle. So that is one new provision which has been provided. Then there is a provision for commitment that we have just done a prima facie order. Investigation has just begun. And at that stage, we allow the party to come and say that, well, I am willing to undertake these remedies and I am willing to correct the market and the investigation may not be carried forward. Thereafter, after a public consultation process, then we can close the matter. Similarly, when we look at dynamic digital markets, there in combination regulations, we have brought in the deal value threshold. They're saying that you may not meet the asset turnover thresholds because a lot of services now are being provided free. WhatsApp service is free to everybody. So they don't have any asset turnovers in India. But the kind of deals that such entities might be undertaking, in case they meet a certain threshold, they are strategically important, then we look at them. So that is a new framework also which has been put in place. Similarly, the leniency plus, we've also tried to enhance that cartels, we need to get more cartels, more information about cartels. So we're giving additional incentives to leniency applicants. Another aspect where things are changing very rapidly is artificial intelligence. And there's so much of rapid adoption of artificial intelligence by all the entities, all various enterprises. And this is something where we don't wish to jump in very quickly because India has the third largest startup ecosystem of the world. So we don't want to come down heavily on any innovation, stifle it, or take any action which is in some way knee-jerk. So we had undertaken a market study on artificial intelligence and competition. And through that market study, we've tried to understand how the AI is panning out. And we've come to the conclusion that there are a lot of efficiency and innovative gains which are coming. However, hidden inside, there could be some potential competition concerns. So instead of rushing in and giving out some guidelines, we thought we'd first only look at giving some guidance. So we've said, okay, we will watch from the sidelines And we've recommended that the government should continue what they are doing, which is in terms of enhancing the access to data, compute, infrastructure, and also building up of AI capabilities. So that is something which we are fully supporting. On the other hand, we are saying stakeholders need to be aware. They need to self-audit and ensure that in case there are any potential competition concerns, those are addressed immediately by the concerned players in the market, so that the Commission doesn't need to even intervene, because we are still allowing AI to pan out for entities to be able to scale up from startups. We are looking at unicorns to come from India. So therefore, we are not immediately taking any action on that. So coming to the conclusion, I would say that the effectiveness of our competition law rests on 3 pillars, which is a forward-looking legislature, a vigilant regulator, and a judiciary that will provide us legitimacy, validity to our actions, and will also guide us wherever it needs to, keeping in view the broad constitutional principles in mind. Going forward, we would always look at the judiciary for guidance, and we also look at the crucial role which is played in balancing the principles of market efficiency, fairness, and proportionality. And as we move towards new frontiers, which is digital ecosystems, artificial intelligence, and cross-border commerce, the dialogue between the judiciary and the regulator is very crucial for us, and that is how we are here. I am extremely grateful to Honorable Chief Justice for giving us this opportunity. I really appreciate the opportunity given to us, and to Madam Honorable Justice Mudgal as the Karnataka Judicial Academy, because we feel that with this we are able to put our points across and also share the kind of challenges that we are facing and how we are trying to address those. Once again, thank you very much. Jai Hind.
Thank you, Madam, for setting the tone for today's deliberations. It is now my privilege to request Honorable Shri Justice Vibhu Bhakru, the Chief Justice, High Court of Karnataka and Patron-in-Chief, Karnataka Judicial Academy, to deliver the inaugural address. Please, Madam.
Justice Mudgal, the Judge of the High Court of Karnataka and the President of the Karnataka Judicial Academy, my sister and brother judges, Chairperson Srimati Ravneet Kaur, Director, Mr. Sukesh Mishra of Competition Commission of India, New Delhi, all the Additional Solicitor General of India, Mr. Kamath, the Registrar General and Registrars and other officers of the High Court, other officers of the Competition Commission, Director and other officers of the Karnataka Judicial Academy, all other members of the legal fraternity, faculty, academicians, and participants, ladies and gentlemen, good evening to everyone. It gives me great satisfaction to be present here this evening to inaugurate the advocacy workshop on competition law and judicial trends, a theme that is of contemporary relevance and enduring significance to our legal and economic framework. At the outset, I would like to extend warm welcome to all participants, members of the judiciary, the bar, regulators, economists, and academicians who have come together for this program. And I must begin by appreciating the thought behind organizing this event, which is to promote awareness and dialogue on issues that shape the very foundation of our economic system. If you look back, the journey of competition law in India mirrors the journey of our economy itself. In the early decades after independence, the focus was on preventing monopolies and concentration of wealth, and that was reflected in the Monopolies and the Restrictive Trade Practices Act of 1969. I remember when I joined the practice, MRTP used to function from Shahjahan Road in Delhi. The matters before MRTP were largely related to unfair trade practices and restrictive trade practices. Almost inevitably, only 2 issues were framed: whether there is unfair trade practice or whether there is restrictive trade practice. Evidence was only led on those 2 issues. And we used to, on a lighter vein, we used to be very glad when we knew the matter was for issues and you would get fee for one appearance for just 2 issues You didn't have to read anything else. But as economy opened up and evolved, the country felt the need for a proactive market regulation and a more modern market-oriented framework. That transition happened with the Competition Act of 2002. This act represented not just a change of law, but a change in philosophy, a shift from control to competition, from restriction to encouragement, and to some extent, from regulation alone to facilitation. It recognized that a healthy market economy thrives when there is a level playing field and the abuse of dominance by enterprises is checked. Now, competition law is often seen as an economic or a commercial subject, but at its core, it's deeply anchored in constitutional values. It carries forward the spirit of Article 14, which promises equality before law. Translated in competition law, it's a level playing field. And of course, Article 19(1)(g), which protects the freedom to practice any profession or trade. But that freedom, as we know, cannot be absolute. It cannot allow one entity to dominate or distort the market to the detriment of others. In that sense, Competition Act safeguards not only the market, but also the democratic principle of fairness. It ensures that economic liberty does not become economic inequality. The judiciary over the years has played a key role in shaping how competition law is interpreted and applied. This act has thrown up very interesting issues, and all of you must be really aware of them. I thought at this stage I will list out some, but considering that several issues may still be live before the court, I think the wisdom would be to refrain from mentioning this. But one thing very interesting about the Act that I think I would mention is that it has a non-obstante clause. That means the provisions of the Competition Act would be given effect to notwithstanding any other law for the time being in force. At the same time, you have another provision which says the provisions of this Act are in addition and not in derogation of any other act. Now, the tension between these two provisions, that one overrides and the second says it's in addition and not in derogation, throws up really interesting issues. And I'm sure most of us have grappled with it at one time or the other. The courts have emphasized three important principles. First, the need for due process and fairness. Second, the importance of sound economic reasoning and evidence. And third, the value of coordination amongst regulators. These principles have helped competition law evolve not as an isolated branch of regulation, but as a part of a larger fabric of administrative and constitutional law. Today, the nature of competition itself is changing. We are in an era of digital markets, big data, artificial intelligence, and global platforms. Businesses no longer compete just on the price or quality. They compete on data, on algorithms, on access to consumers. In such a landscape, the traditional understanding of dominance or market power becomes more complex. As judges, lawyers, and regulators, we have to continuously adapt to new realities. We must develop a deeper understanding of technology, economics, and global business practices because competition issues today are not just national, they're international. Every decision in competition law carries with it wide-ranging of implications, not just for the company or the industry, but for the economy and the public at large. That is why judicial interpretation must be guided by economic understanding and the constitutional values. I believe programs like this, where judges, lawyers, and regulators and policy experts come together, are essential. And I thank the organizers for this event. Thank you. Jai Hind.
Thank you, Your Lordship, for your inspiring words and guidance. Moving forward, the spotlight now turns to the presentation titled Brief Introduction of Competition Law and Judicial Trends. I request Shri Sukesh Mishra, Director, Competition Commission of India, to kindly make the presentation and guide through the key counters of the subject. May I kindly request the dignitaries, honorable dignitaries on the dais to take their seats in the front row.
Check.
Good evening, Honorable Chief Justice Sir and Honorable Judges of Karnataka High Court, Additional Solicitor General Sir, Chairperson Ma'am, my senior officials from the CCI. So the idea of this presentation to just take you through what are the important provisions of the Competition Act, and I'll just discuss very briefly without going into the nuances and the facts of particular case, the important law laid down by the Honorable Supreme Court since 2010 till very recent time. So this objective of the Competition Act has been laid down in the preamble of the Act itself, which talks about 4 noble objectives. This Act prevents practices having adverse effect on competition, promotes sustained competition, protection of consumer interest, and this consumer interest, if this is my understanding, I may be wrong. When we compare with other consumer-centric law, take for example Consumer Act of 1986, it talks about individual grievances mostly. That if you suffer with any services or goods deficiency, so you can go and approach the 3-tiered system provided in the Act. Insofar as this particular law is concerned, the consumers which we are targeting or looking are the society at large. And second fundamental difference which I found myself, that insofar as the awareness of harm, in the Consumer Act, that something has been done against you, so you can go and seek the remedy. Here in cartel kind of cases or AOD cases, which I am going to explain very briefly, the consumer might not be knowing about the ramification or the market distortions. And then ultimately the freedom of trade carried by participants in the market in India. Essentially, it would like to say that the smaller player or the bigger player, they can all participate in the market freely and without any coercion or any duress. So institutional framework, if I would say very briefly, the Competition Act talks about 66 provisions. There are very, very small law. It is not a very big law. And the Act talks about a commission comprising of chairperson and members. Presently, we have chairperson and 3 members appointed by the central government under Section 8 of the Competition Act. And they are from diversified background, from economics, law, public policy, public administration, etc. So they are managing the entire system. Director General is the investigating arm who is investigating pursuant to the direction given by the Commission. So the radical departure here as compared to the MRTP law, whereas in MRTP, the DG has a suo motu power to investigate the matter. But this DG cannot do the matter, investigate the matter suo motu. He has to wait till the direction will be given by the Competition Commission of India to investigate. And then there is an appellate body in the form of ANCLAT. Earlier it was called the Competition Appellate Tribunal, but after the 2018 changes, now the ANCLAT, apart from taking care of other jurisdictional and other policy issues, handling the appellate body of Competition Commission of India. So basically, if I talk about Section 3 and Section 4 are the 2 provisions which are substantive provisions in the law out of 66. And these are all ex post facto laws. So Section 3 talks about variety of agreements. Section 3 has been differentiated into 2 parts. One talks about horizontal agreements and another is called the vertical agreement. This is the popular language, but it has not been mentioned in the Act per se. So Section 3.3 talks about anti-competitive agreement in the form of cartelization, in the form of bid rigging, and as Madam Chairperson was rightly speaking, it is considered as egregious kind of harm, and in America, in US, it is considered as a criminal offense. Whereas in India, there is no criminal liability has been attached to these particular provision. So what exactly the cartelization? When 2 players operating at the same level of business, if they are conniving and fixing the price or limiting the output of a particular commodity or a particular product, ultimately the sufferer would be the consumers at large. to avoid these particular kind of tendencies, the term cartelization has been defined, which was missing in the earlier regime in MRTP law. So the term has been defined in the Act itself under Section 2C. And this agreement, when I am talking about, is far broader than which has been defined in the Indian Contract Act. 1872 law talks about agreement in a very narrow manner, where in this particular law, the agreements are defined very broadly. Even though it is against public policy, it is wrong, still it will be captured under the purview of the Competition Commission of India. And it also includes bid rigging. So in the past, Commission has exercised its right and passed various order on cartelization, cracking many cartelization. Some of the cases upheld by the National Appellate Tribunal or the compact pending in the Supreme Court. I will not unnecessarily name because matter is still sub judice at the highest level. Then we have vertical agreement. It is the completely different category. In vertical agreements, the players are operating at the different level of business. And for instance, it is called tie-in arrangement. The supplier is insisting that if I am supplying a particular product to you, you have to take associate product along with that particular product, or refusal to supply without any objective or justifiable reasons. So these kind of practices are considered as vertical agreements and examined by the Competition Commission of India on the basis of rule of reason, unlike the Section 3.3 concept, which talks about per se violation. So the presumption will be drawn once the agreement has been established. So you have to come and rebut, and it is a rebuttable presumption. Insofar as Section 3.4 is concerned, it is a rule of reason. So the enterprise could come and say that these are the business justification on the basis of which I am pursuing. Please, 15 minutes. Yes. Next provision, substantive provision, which I was talking about, dominance. In earlier MRTP regime, dominance per se was bad. The size considered as one of the factors. But insofar as Competition Act is concerned, we are not concerned with the size of that particular enterprise because of its acumen or of whatever business intelligence they have created their size. But the problem arises once they started creating trouble for the competitor or the consumers. And there are variety of such factors have been enlisted under Section 4 to A to E. I'll not name because of time constraint, I'll just quickly move. Then it is ex ante regime. The combination, if there are some combination which could be the merger, acquisition or amalgamation, crossing the threshold limit in the form of the turnover or asset value, you have to come and ultimately take the approval from the Commission. And if you are not taking the approval and consummate the transaction, then Section 43A will be applicable, where the penalty could be imposed against the erring enterprise. Section 19 is very important. It talks about who and how a person can come before the Competition Commission of India. So a person could be aggrieved, maybe non-aggrieved. A suo motu complaint can be taken by the Commission. This is the power has been given to the CCI, that on the basis of some information, anonymous information or some paper article, the Competition Commission of India could maybe easily take a cognizance of the matter, or the reference given by the statutory body or the central or the state authorities. The process is like this. Once the information received by the Commission, and this word has been amended in 2007, earlier the language was complaint, now it is information. So the language make it very clear that any person can come and make a information or the complaint before the CCI. Once the information received by the Competition Commission of India, the Commission will examine those particular complaint on the basis of merit, and basic minimum requirement has to be seen to make out a prima facie case. If some little evidence is there in the information or in the complaint, the Commission could direct the DG to investigate and submit a detailed report in the matter. Upon receiving the instruction or the direction under Section 26(1), the DG has to investigate and complete the work and submit the report with his finding and evidence and everything. And this DG has a power to even allow cross-examination, which is usually very rare in any investigation proceedings. Then subsequently, after getting the report, it is the duty and it is the due process which we comply as a commission to share the reports to the parties, seeking their objections, soliciting their comments, and based on that, and after giving due opportunity of oral hearing, a final order will be passed, whether to close the matter or to impose some monetary penalties. Section 32 talks about the provisions, the jurisdiction of the commission for if the offence is happening in India but the conduct is occurring outside India. For instance, two tech giants, if they are colluding and making some distortions concerning the Indian markets, so this extraordinary jurisdiction which paved the way to the Competition Commission of India to look into those kind of particular issues and can provide appropriate remedies. Then Commission has power to pass interim orders. So interim orders can be after the prima facie order has been passed and where Commission feel that maybe some kind of harm is, imminent harm is there, or maybe the party will be suffered which cannot be compensated in due course. Then Section 36 talks about the principles of natural justice, the due process. In this particular provision, the Commission has power to regulate its own procedure. But the important thing is the compliance of natural justice. Other than that, Commission do have power under the civil code, but not all the power, and they are not even bound by the civil code procedures. So it is a very summary kind of proceeding which Commission keep on doing as a regulator. Section 27 talks about the orders once there is a contravention has been upheld by the Commission under Section 3 or Section 4. Under Section 27, Commission can issue variety of orders, including cease and desist order, which is very popular from the time of MRTP law, and then even the penalty up to 10% of turnover. In case of cartelization, 3 times of the profit. So Commission could pass any of such order against that particular erring entity. Very recently, the Commission came out with the penalty guidelines. So based on that guidelines, the Commission keep on computing the penalties, and on the basis of which a due process will be followed and an appropriate penalty order will be passed. Then there are certain provisions which talks about non-compliance of the order of the Commission under from Section 42 to Section 45, where Commission can even impose penalties for 1 lakh rupees for non-compliance or of the Commission's order, and there are a variety of provisions have been provided. Section 46 talks about a very relevant and very noble particular point. Section 46 talks about leniency. If somebody has committed a cartelization, he could come to the CCI and say that, see, I was involved in the cartelization and I want a mercy in the form of leniency. So the first person who is coming to the Commission called as a marker status, Commission will provide a marker status. The very first person will get 100% of penalty reduction. The second person would get around 50%, and third person onward 30% reduction in the penalties. But provided you have to make honest and true disclosure of the cartelization. Section 48 talks about the liability of the officers, because any company which commit a contravention, obviously the officer should be behind to connive that particular cartelization or any kind of this practices. So this is akin to the provisions which we have normally read in Negotiable Instrument Act and other laws. Then High Court power. Under writ jurisdiction, we all know High Court has the power of judicial review of any action and every action of the Competition Commission of India. Under the supervisory jurisdiction, under Article 227 as well as 226. So High Court can issue any kind of writs and correct the action of the Commission if deemed fit in case on the basis of case-to-case basis. Now, the second part of my presentation would be comprising of 6 judgments of Supreme Court. Can you just change the slide, please? This is the very first judgment, a very seminal judgment on the jurisprudence of Competition Commission of India, decided by the three-judge bench, presided by Justice Kapadia and authored by Justice Swatantra Kumar. A very beautiful judgment, and it talks about the length and breadth of Competition Commission of India, what kind of order could be challengeable, what kind of order cannot be challenged. So Section 26(1) order, for instance. Right of PNJ, so that stage is exempted as far as this particular provision is concerned. Whenever commission is closing the case, on the contrary, under section 26(2), the commission has to close that matter and give reasons, and that can be challengeable before the National Company Law Appellate Tribunal. The second judgment was Excel Crop judgment. There was a cartelization by 3 firms in the Food Corporation of India tender. And there are 2 important principles have been laid down in this particular case. One was that the penalty should be levied as per the proportionality system. If there is a multi organization which is doing variety of work, so a particular company, wing of that particular company is doing some kind of cartelization or bid rigging, so that particular part would be penalized, not the entire setup. And the second part was, while DG investigated this particular case, tender, he got to know that in that particular tenders also there was some distortions. So there was a plea before the Honorable Supreme Court that this particular tender was not covered, and as per, unlike that MRTP, this DG doesn't have the suo motu power. But the Honorable Court differentiated, saying that when DG is investigating a particular case, he has to investigate thoroughly and comprehensively, and accordingly, they found that there was nothing wrong has been done by the DG in this particular case. Bharti Airtel was a case in which the principle of judicial, the committee between the regulator was decided by the Honorable Supreme Court, led by Honorable Justice A.K. Sikri, and there is a very important judgment and a important guidance to the Competition Commission of India. And keeping in view of peculiarities of that particular case, the sequencing has been provided by the Honorable Supreme Court. Many a time, councils have argued that now law has been laid down, but we have differentiated and distinguished this judgment many a times, saying that that was in the context of a particular case, not as that in every case the CCI is to wait till the sectoral regulator could decide the matter. Next, please. Samir Agrawal was a case where the commission closed the matter against Ola and Uber by passing a prima facie closure order. That order was carried in appeal by, I think, a lawyer before the ANCLAT. ANCLAT upheld our order. However, they said that since you don't have a locus, so we are not entertaining this on this ground as well. The matter carried subsequently in appeal before the Supreme Court. The Honorable Supreme Court upheld our order, but insofar as parties are concerned, they said that because law is now very stressed and wide, any person can come before the Competition Commission of India. So any spirited person who feel that there are some kind of distortions in the market, so they can come to the Competition Commission of India. Coal India was again an issue took up by the Coal India, saying that we are the government company discharging sovereign function. There are catena of judgments on sovereign function, deciding the sovereignty and non-sovereignty from the peninsular navigation to Vidyavati and so many other judgments. Citing all these judgments, the Honorable Supreme Court held that Coal India is doing a commercial function. They cannot claim the sovereign immunity. Finally, the short glass judgment, as Madam Chairperson was rightly pointing out, has provided the guidance to the Competition Commission of India that in Section 4 cases, you have to look into the appreciable adverse effect on competition. And this is a very important judgment. And recently, the Honorable ANCLAT, taking cue from this particular judgment, said in Meta and WhatsApp judgment that even qualitative evidence is sufficient. There is no requirement to go into the quantity. So I think maybe I can take a halt here. Thank you very much for giving this opportunity. I'm really grateful. Thank you very much.
Thank you, sir, for that comprehensive and insightful presentation. May I request the Honorable Chief Justice and other dignitaries to kindly grace their seats on the dais to proceed with the further. Please, ma'am. May I request Honorable the Chief Justice, Shri Vibhu Bhakru, the Chief Justice, High Court of Karnataka, to present a book to Shri Sukesh Mishra, Director CCI, as a token of our appreciation. May I request Shri Sukesh Mishra to kindly come on dais. I also sincerely request the Chief Justice to present book to Shri Indrapal Singh Bindra, Secretary CCI, Shri Arpan Mishra, Deputy Director CCI, and Srimati Jyoti Banot, Senior Economist from CCI. May I kindly request them to please come on the dais. Thank you, my lord. To conclude the formal proceedings, I request Shri Indrapal Singh Bindra, Secretary, Competition Commission of India, to propose vote of thanks.
Namaskar. Honorable Chief Justice of the Karnataka High Court, Honorable Shri Justice Vibhu Bhakru Sahab, Honorable Srimati Justice K.S. Mudgal, President Judicial Academy, Bengaluru, Honorable Judges of the Karnataka High Court, learned members of the Bar, Madam Chairperson of the Competition Commission of India, Madam Ravneet Kaur, and respected dignitaries present here today. It is my proud privilege and honor to propose this vote of thanks on behalf of the Competition Commission of India on this significant occasion that marks a meaningful step forward in deepening the engagement between the judiciary and the competition regulator. At the outset, I wish to place on record our deep sense of gratitude to the Honorable Chief Justice of Karnataka High Court for sparing his valuable time and agreeing to this advocacy event, which is being organized by the Competition Commission of India as a part of statutory mandate. Your Lordship's vision in fostering a dialogue between the bench and regulatory institution is truly commendable. This interaction stands as a testament to the collective commitment of both institutions to uphold the rule of law and to advance fairness, transparency, and accountability in the markets. I would also like to convey a sincere appreciation to the Honorable Judges of the Karnataka High Court for their gracious presence and insightful participation. Your Lordship's observations have enriched today's discussions and will continue to inspire us in fulfilling our statutory responsibilities with diligence and integrity. A special word of acknowledgement is due to the Director, Karnataka Judicial Academy, for her coordination and support in making this event possible. The Academy's effort in encouraging interinstitutional dialogue deserves high commendation. We also express our gratitude to the Registrar General and the administrative staff of the Karnataka High Court for their meticulous coordination and warm hospitality, which have ensured the seamless conduct of this program. This event today is a reflection of the spirit embodied in Section 49 of the Competition Act 2002, which enjoins upon Commission the duty to undertake competition advocacy with policymakers, regulators, and other public authorities. The judicial regulatory interface thus serves as a forum where the complexities of modern markets meet the interpretive wisdom of the bench. The enlightening conversations of this session are expected to open new vistas of understanding on how competition law interacts with the broader questions of governance, market structure, consumer welfare, and digital transformation, and has enriched our institutional knowledge. Before I conclude, I once again extend our heartfelt gratitude to the Honorable Chief Justice for his inspiring leadership and for gracing this occasion with his presence, to the Honorable Judges of the Karnataka High Court for the valuable time and insights, to Madam Chairperson CCI for her vision and guidance, and to all the officers of both the institutions who have made this program possible. It is our earnest hope that the dialogue initiated today will continue to grow into a sustained framework of mutual understanding, contributing meaningfully to the advancement of competition law and economic justice in India. With these words, I convey my heartfelt thanks to all dignitaries and participants present. Thank you. Jai Hind.
Thank you, sir, for your words of gratitude. As we bring this program to a close, may I now request everyone to kindly rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you all. On behalf of the organizers, I thank you all once again for your gracious presence, wishing you a pleasant evening ahead. Thank you.
Recordings.